Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. Professional ethics class. Friends, in the last video, we discussed the topic of right to practice, section 29. I think we have discussed in detail along with two cases also. So, now we are going to discuss section 30. So, section 30 deals with the right of advocates to practice in the Supreme Court, in any court in India for that matter, in the Supreme Court, or before any High Court, before any local court, or that means Sessions Court or Magistrate Court. Also before any tribunal. You all know what is a tribunal. Tribunal is another authority where specialized members in the particular field, they will be sitting under the head of the judiciary, like administrative tribunal, labor tribunal, we can call it as a labor court. So many administrative tribunal, central administrative tribunal, electricity tribunal, so many tribunals will be there. There, a judicial officer will be there, but he will be assisted by two members who are efficient, proficient and experts in the particular field. For example, if it is administrative tribunal, some IAS or IPS officer will be there. He will be dealing with the matters of suspension, reduction in the time scale of pay, likewise. So they will be knowing very much. Normally, you people, if I ask you what is the reduction in the time scale of pay, you will be confused, even though you know the law very well. So that is the tribunal. Yes, you can go and argue before the tribunal. And you can go and argue before any authority before whom the lawyer can practice. Just like commissions of inquiry. Commissions of inquiry. Yes, if some inquiry is going on, you can go and represent, you can go and cross-examination the commissions of inquiry also. Like that, wherever a lawyer is allowed to practice, according to section 30, lawyers can practice in the said courts. I think you don't have any doubt in this regard. Right. So, section 30, the subheading is like this: right of advocate to practice. Okay, now we'll deal with a couple of cases. Number one, Anant versus Anant, son of Narayan Nayak versus State of Maharashtra, 1989. This is a classic case where, according to section 44B of the Land Sealing Act, the lawyers are prohibited to argue before the revenue officers. This is the main problem. You may know what are civil cases and what are not civil cases. For example, if you want to get a dispute resolved regarding a caste, suppose for example, there is a caste by name Semban in Ongole. So the revenue authorities, they are only the competent persons to give a certificate whether you are a Semban or not. So, or something, some Idiga or not. But these castes are extinct, but still people claim under BC or SC quota. So therefore revenue court is the only competent, revenue people are only competent authorities to give, but not the civil court. Likewise, Land Sealing Act, the advocates are prohibited from appearing in land sealing cases according to section 44B. But in this case, Honorable Supreme Court of India stated that the land matters, yes, definitely, even though they are not directly civil matter, even though they are directly revenue matters, some civil litigation is definitely there, will be there. Therefore, the lawyers, yes, they are entitled to practice. So you can't simply say that lawyer cannot entertain the wakalat in that particular case. No. So that means the right of advocates to practice is affirmed in this particular case law. Let us go to the second case law. R. Durga Prasad versus Union of India and another, 1998. So normally in the family courts, we are under the impression that we have been seeing the advocates wearing the robes and attending before the court. But in family court, there is no necessity of a lawyer. Because the family judge, he has to do the so-called counseling. He must try to resolve the dispute between the families. There is no necessity for an advocate. Of course. But please remember, if the party is not able to explain the grievance legally, then they can engage the advocate. So advocates can practice in the family courts also, particularly in matters of Section 12 of the Hindu Marriage Act and marital disputes. So sometimes when the marriage is done by force, when the marriage is done by using pressure, all these things, legal practitioner can be engaged to practice, even though it is not important, it is not necessary as per section 7 of the Family Courts Act. So section 30 is most important. Section 29 says advocates are only the class of persons entitled to practice. Then this gives a right, an exclusive right for the advocates to practice in different courts. What are courts? Right from Supreme Court to the lower court you can appear. But straight away you cannot barge into Supreme Court and say, I am, Your Honor, I have got enrolled. No. You have to write the advocate on record examination, and then only after passing the examination you will be allowed in the Supreme Court. Why? Because Supreme Court can state its own procedure. It is a constitutional body. Yes, to practice in Supreme Court, you must have some experience. That experience is in the shape of advocate on record. So, once you become an advocate on record, definitely you can practice in the Supreme Court of India also. So, please remember these two case laws and section 30. You may get a question in this particular topic. Okay, with this I am concluding. Thank you very much.